from daily list for hearing under order 41 rule 11 item 13 second appeal 600 of 2017.
Make clean hardship. My lord, this is a second appeal by the plaintiff. Trial court and the appellate court both have dismissed the suit. My lord, you are permitted to place from the appellate court judgment. Relief has been recorded at page 15, the internal page 3 of the appellate court judgment. In the middle, the plaintiff seeks the following reliefs. May I read, madam?
Please achieve directly confirmation of possession.
My lord. An injunction was accepted. Lord, the case of the plaintiff is, my lord, that the suit land exhibit C, Schedule C is a part of the entire land of Schedule B, my lord, held by
Schedule C is the suit property.
C is the suit property. That is a portion of Schedule B.
Part of Schedule B. What is Schedule A?
Schedule A is the genealogy. Well, one Mandal Hemram was the recorded tenant in the Khatna. He left behind 3 children: Khedma Hemram, son; Sukarmani, daughter; and Poki Hemram, another daughter. So 1 son and 2 daughters. Khedma died in 1965 issueless, and his wife predeceased him. Sukarmani was blessed with 3 sons: Lakhiram Murmu, Ruplal Murmu, and Gopan Murmu. They are the plaintiffs number 4, 5, and 6, and 3 sons of Poki Hemram Murmu Milan, Sitaram Murmu, Piru Murmu, and Chand Murmu. They are plaintiffs number 1, 2, and 3.
See, 3 sons, Lakhiram, Ruplal, and Putna. What plaintiff number 4 and 5 क्यों?
4, 5, 6.
6 होगा ना?
Ji.
So the descendants of 2 daughters are the plaintiffs.
We are the plaintiffs. Now what happened, Millard? The defendant, Millard, wanted to dislodge us from our legally held property, and they obtained a sale deed, Millard. They are also tribals, so the Rayati lands could be transferred from one tribal to another. They said that wife of Hedma Hembrow Miller, known as Mangli Hembrow, she has transferred the property after taking permission of the LRDC under section 46 of the CNT Act.
When?
Miller in 1985.
And when did this Hedma Hebron die?
He died in 1965. So 20 years after death of Herma, it is said that Mangli was
His wife had predeceased him.
yes, he according to
So
the
85
plaintiff,
में कैसे?
according to us plaintiffs, wife of Herma Hembrom died before the death of husband,
It's a registered deed in 1985.
1985, by Mangli. Now, my lord, may kindly
Mangli, wife of which you said that she died long back. It's a case of impersonation.
yes, it's a case of impersonation. Then I will come on that, Miller. The very foremost thing which comes to my mind, that taking permission for transfer of land by one tribal to another tribal would be upon the permission granted by the deputy commissioner under section 46 of the CNT Act. Here, Miller, by annexure E, they have placed on record exhibit permission granted by LRDC. That itself shows that a illegal transfer had taken place. It could not be transferred unless the deputy commissioner gives permission.
Did you challenge the said deed?
My lord,
Did you challenge the said
I
deed?
had no knowledge. It has come in the exhibit, my lord. So now it's a point of law. I can raise it at this stage even. And I don't know how this lacuna could not be noticed by the learned two courts below. A permission by LRDC was nothing. It was by authority who had no jurisdiction to grant permission. If I am permitted to read section 46 proviso 1 small a, provided further that an occupancy rayat who is member of a scheduled tribe may transfer with previous sanction of the deputy commissioner his right in the holding or portion of his
LRDC is what? Land Reform Deputy Collector.
जी.
उनका क्या status है? He is subordinate to deputy
is
commissioner.
too subordinate. It is like a executive magistrate. He would then subsequently be promoted to the rank of SDO, then additional collector, and then if he is promoted to IS, then he will become a deputy commissioner. LRDC is a very lower post, that compared to deputy commissioner. So this is one point. And there are judgments also, if my lord permits me, I can place for my lord's kind consideration.
Which section are you referring to?
Section
46?
56.
46?
Sorry, section 46,
कौन सा subsection?
CNT.
कौन सा subsection?
My lord,
Subsection कौन सा?
my lord, section 1, 46, section 46,
कौन सा subsection?
section 46, CNT Act, section 46.
बताइए ना, इतना लंबा section है ये. कौन सा
नहीं,
subsection?
उसका 1 का small a proviso provided further that 1 में कहते हैं 46(1) है no transfer by a rayat of his right in his holding or any portion thereof by a mortgage, lease, etc. provided further that A, an occupancy raier who is member of a scheduled tribes may transfer with previous sanction of the deputy commissioner his right in the holding or a portion of his holding by sale, exchange, gift or will to another person who is a member of scheduled tribe and who is resident within the local limits of the area of the police station within which the holding is situated.
That's right. What else?
My lord, the finding, my lord, is given from paragraph 5. Finding is, my lord, from paragraph 30, my lord, page 9, page 10,
Para 29.
29. You see. DW9 is Fatih Chand Sen. He has proved the 3 certified copy of sale deeds which are marked as Exhibit C, C by 1 and C by 2 and by sale deed C by 1, defendant has purchased the suit property. Now, from the oral documentary evidence of both these sides come to plaintiff witness have stated that the relevant.
नहीं अब सारे relevant है सर एक पेज पढ़ लें
हाँ एक मिनट हम पढ़ लेते
आराम से पढ़ें
हैं. From the paragraph 29, from the oral and documentary evidence of both the sides, it has come that plaintiff witness has stated that the suit land was recorded in the name of Mondal Hemram, alias Rupu Hemram, and Mondal Hemram had died leaving behind his 2 daughters, namely Sukarmani and Poki. And plaintiff are sons of Sukarmani and Poki. And Mandal Hemram died leaving behind his son Hedma Hemram, who died issueless, and his wife was predeceased, and there is no another name of Hedma Hemram, whereas the witness of the defendants have stated the Hedma Hemram who also known as Rupu Hemram, and he was leaving behind his wife Mangli Hemram, who has executed the sale deed in favor of the defendants by Exhibit C by 1. The defendants' witness have also stated, after getting permission, defendants have purchased the land from Mangli Mani. Para 30. Exhibit E is the certified copy of order of MR case number. This is permission case number such and such of dated 15/11/85, by which learned LRDC has granted permission to Mangli Manjiai under section 46 of the CAT Act for sale of the land. Exhibit E by 1 is the certified copy of the Bedakli case number so and so, dated 22/12/86, which confirms that defendants have purchased the suit land by registered sale deed number so and so, dated 8/11/85, Exhibit C by 1, and so the land was of Jeevan Soren. These 2 exhibits show that defendants have purchased the suit land from Mangli Manjiai after getting permission under section 46 of the CAT Act. Now, if I am permitted to submit further, a lady cannot have absolute right to sell the property of her husband. And a 33 Miller also, the learned lower appellate court holds it has come by the documentary evidence by exhibit E and E by 1 that defendant has purchased the suit land from Mangli Manjanian after getting permission under section 46 of the CNT Act. There are two questions arise, Miller. Whether under section 46 LRDC has any right to grant permission to transfer the property. Number two, Miller, under the custom of the tribal,
सर कस्टम को प्लीड करना होता है, प्रूव करना होता है.
Miller, a
कस्टम
lady,
को प्रूव नहीं हुआ है.
Miller,
इसलिए
यहाँ
हम
पर
लोग नहीं
तो
जानते.
यहाँ पर तो लेडी ट्रांसफर कर रही है the property of her husband that has come in the written statement also. She has no power. उसको सिर्फ मेंटेनेंस का पावर है, लाइफ टाइम इंटरेस्ट है उसका
कौन सा law?
इंस्टीड ऑफ मेंटेनेंस
कौन से लॉ?
है. हम आपको जजमेंट
ट्राइबल लॉ में ना.
नहीं हम मतलब under CNT Act it has been held by this honorable court as well as by the honorable Supreme Court that a tribal lady doesn't have absolute right to transfer. This is the up to date
So
position.
these are the two questions of law involved.
हाँ
और कोई क्वेश्चन नहीं.
है. इसके अलावा सेक्शन 50 में with this Mangli Manjai was alive, she was not put to the witness box. अगर
She
उनका
died in
evidence
1988.
हाँ 85 का उनका सेल है,
88 में डेथ हुआ है. सूट है 90 का.
सूट है 90 का,
तो
लेकिन
कैसे वो विटनेस के लिए आती?
ठीक है, but she was never examined.
How can she be examined?
Well, in this not
Her
in,
death certificate has been produced showing that she died in 1988.
very well Miller, but even then
रजिस्ट्री की थी ना.
ये दो पॉइंट तो है.
और कोई पॉइंट है?
मैं हम देखते हैं उसका जजमेंट हम रिलाई करना चाहते हैं.
अभी जो जजमेंट
Yes. Well, I will rely a lot on the judgment of this honorable court rendered by a honorable division bench. In which Miller, para 11 I will like to place before the worship. Para 11 and internal page 7 of the judgment. May I read? There is no dispute about the settled position of law that the issue of jurisdiction can be raised at any stage of the proceeding as the issue goes to the root of the list. Here, Miller, if the permission was not granted by Deputy Commissioner, then the sale was also illegal. Now, the other judgment for my lord's kind consideration. Another judgment by this honorable court itself. Of 2024, a division bench of this honorable court, in the case of Ruby Singh versus Secretary, Ministry of Jal Shakti, Government of India, has been pleased to hold at para 41, internal page 11 of the judgment. it is further settled position of law that even right decision by a wrong forum is no decision, as has been held by Honorable Supreme Court Chutia in Pandurang and others versus State of Maharashtra, 1986, 4 SEC 436. Pardon. Then the Lordship have quoted paragraph 4 of the said judgment of 1986 Supreme Court. When a matter required to be decided by a division bench of the High Court is decided by the learned single judge, the judgment would be a nullity. The matter having been heard by a court which has no competence to hear the matter, it being a matter of total lack of jurisdiction, the accused was entitled to be heard by at least two learned judges constituting a division bench and had a right to claim a verdict as regards his guilt or innocence at the hands of the two learned judges. This right cannot be taken away except by amending the rules. So long as the rules are in operation, it would be arbitrary and discriminatory to deny him this right, regardless of whether it is done by the next page below, reason of negligence or otherwise. Deliberately it cannot be done. Negligence can neither be invoked as an alibi, nor can cure the infirmity or illegality so as to rob the accused of his right under the rules. What can be done only by at least two learned judges cannot be done by one learned judge. Even if the decision is right on merits, it is by a forum which is lacking in competence with regard to the subject matter. Even a right decision by a wrong forum is no decision. It is non-existent in the eye of law, and hence a nullity. The judgment under appeal is therefore no judgment in the eye of law. This court in the state of, then some judgments have been referred. One more judgment of this Honorable Court will have rendered in 2004 August by 2024 August, rendered by a Honorable Division Bench in the case of Assistant Commissioner of Income Tax versus Mekong Limited. At para 40, their lordships have considered this aspect. If I am permitted to read para 14. Page 4, नीचे में page 4 लिखा हुआ है, 4 of 10 page. Para 14, if I am permitted to read by now. Shall I proceed?
Yes, I read it.
Para 14, the further settled position of law is that if any statute has been enacted, there cannot be insertion of any word beyond the contents of the statute, and the statute is to be followed as it is, and there cannot be any deviation. यहाँ पर वो जो डिप्टी कमिश्नर साहब को देना था, sanction उन्होंने LRDC साहब ने दिया, so that becomes an LT matter, and therefore the entire process of sale became illegal. So on the
सेक्शन 3 सबसेक्शन 8 के बारे में आपको क्या बोलना है?
In CNT Act, madam, section 3, madam.
सेक्शन 3 सबसेक्शन 8
One. Definition.
पेज नंबर 5 अगर आपके पास ये
जी
किताब
जी हाँ वही होगा. Deputy Commissioner in any provision of this act includes revenue officer or deputy collector who is especially empowered by the state government to discharge any of the functions of deputy commissioner under that provision. इसके बारे में but in my humble submission that embargo that is not applicable so far the grant of sanction under section 46 of the CNT Act is concerned.
Anything else you want to say?
My lord?
और कोई पॉइंट है आपका?
हाँ. And so far, my lord, one judgment is rendered by this honorable court in the case of Matheus Tirki versus Josephine Lakra. Paragraph 11, if I am permitted to read. Section 46 of the Chhotanagpur Tenancy Act 1908 imposes restriction on transfer by a rayat of his right in his old age, holding by way of sale, gift, and mortgage or lease. Proviso to Section 46(1) allows a occupancy rayat who is member of scheduled tribe to transfer his right in his holding or a portion of his holding. Next paper. Holding by way of sale, exchange, gift or will to another person who is member of the scheduled tribes with the previous sanction of the deputy commissioner. So it is not any other person than the deputy commissioner himself. Thus, the right which may be transferred by way of sale, exchange, gift or deed is occupancy right only of a rayat in his holding. Yet the instant case, the widow of Ludo Mato, who could have had only a life interest in the properties of her husband in lieu of her maintenance, had executed the deed of gift in favor of her daughter, and permission for the transfer of properties was granted by the deputy commissioner, purportedly in exercise of his powers under Section 46 of the CNT Act. The execution of the impugned gift deed by widow of late Ludo Mato had the permission granted by deputy commissioner, by the deputy collector for transfer of right over the lands under the gift of defendant were illegal and improper. Then it again says the defendant one could not have acquired any legal right over the land under the deed of gift which was executed by her in her favor, since the donor had no legal right to gift away the properties. यहाँ भी मंगली मनयान को पावर ही नहीं था सेल करने का. The trial court appears to have totally misconceived the principles of law in context of the customary law applicable to the parties. As such, the finding of the trial court on this issue is bad and not sustainable. this is in my humble submission giving me to make a submission that a lady had no right to transfer the title by way of sale deed to the defendants. Number two, Milord, permission of the deputy commissioner was not.
Kindly don't repeat.
So these are the two humble submissions we made today for the purpose of admission.
You have the learned counsel appearing on behalf of the appellant. The second appeal has been filed against judgment and decree dated 16/9/2017 passed by learned District Judge Roman to Dhanbad, whereby the appeal filed by the plaintiffs has been dismissed. It was numbered as Civil Appeal number 13 of 2010. The trial court judgment was passed. The trial court judgment is dated 2011-2009, passed by learned subordinate Judge Roman 6 Dhanbad in title suit number 83 of 1990, whereby the plaintiff's suit was dismissed. The suit was filed seeking declaration of right, title and interest over Schedule C property and its confirmation of possession in favor of the plaintiffs, and if ultimately plaintiffs are found dispossessed, for its recovery of past possession and permanent injunction restraining the defendants from interfering with the peaceful possession of the plaintiff. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but substantial question of law arise for consideration by this court. He submits that the defendants had claimed that they were in possession of the property by virtue of registered sale deed executed by Mangli Manjhain, wife of Hedma Hendrin, registered sale deed का dated 8/11/1985. After taking permission from Land Reform Deputy Collector Dhanbad under Section 46 of Chotanagpur Tenancy Act, by the order dated 5/11/1985 in MR case number 127/8586. He has referred to the provisions of Section 46 of the Chotanagpur Tenancy Act and submits that Land Reform Deputy Collector has no jurisdiction to grant permission, and therefore the very basis of execution of the sale deed was bad, and consequently the permission being void, the sale deed was also void. He has further submitted that under the tribal law, the wife विडो थी वो रूपा हेम्ब्रम थी ना मंगली मंजाइन
Mangli Manjan is said to be wife of
रूपा रूपू
रूपू
ओके रूपा मंजाइन
और हेडमा का बोलते हैं कि हेडमा का एक और नाम था वो रूपू था.
ठीक
But it has
wife of the Mangli Manjain, being the widow, had no right to sell the property of her husband after his death. The learned counsel has also submitted that since she had no jurisdiction to sell the property as per tribal law, therefore the sale deed was void and null. The learned counsel has also submitted that although these points have not been raised before the learned courts, but they being pure question of law can be raised even in the second appeal. He has relied upon the judgment passed by this court in LPA number 242 of 2022, decided on 17th of November 2022. In the appeal arising out of a writ petition, wherein in paragraph 11 it has been held that there is no dispute, it has been observed that there is no dispute about the settled position of law that the issue of jurisdiction can be raised at any stage of the proceedings, as the issue goes to the root of the case. He has also relied upon the judgment passed by this court in tax appeal number 11 of 2023, filed under section 260 capital A of Income Tax Act, and has referred to paragraph 14 thereof, that it has been observed that it is settled position of law that if a statute has been enacted, there cannot be any insertion of any word beyond the content of the statute, and the statute is to be followed as it is, and there cannot be any deviation. And this is based on the principle that a thing is to be done strictly in accordance with the statutory provision, and there cannot be any deviation from statutory command. Here, he has also relied upon the judgment passed by this court in WPS number 205 of 2023, a writ petition, and has referred to paragraph 41 to submit that it is settled position of law that even right decision by a wrong forum is no decision. And in the same judgment, a reference has been made by this court to a judgment passed by Honorable Supreme Court, reported in bracket 1986 bracket close 4 SCC 436 within bracket Pandurang and others versus State of Maharashtra. The learned counsel has also relied upon the judgment passed by this court in the case of Matthews Dickey versus Dusfuli Lakna, reported in 2008 with bracket 2 bracket close SCR 208 within bracket GHR, and has referred to paragraph 11 thereof to submit that the widow may have, the widow of a tribal may have only life interest in the property of her husband in lieu of her maintenance, and cannot transfer the property by way of gift, exchange, sale, etc. And in that case, the permission granted by the deputy commissioner to give the property was held to be bad enough. The learned counsel submits that the substantial question of law be framed and the case be admitted. On the aforesaid 2 points. After hearing the learned counsel for the appellant, this court finds that the property was admittedly recorded in the recorded tenant of the property was Mandal Hemram, and he has one son, namely Hedma Hemram, and 2 daughters, Sukumari and
Sukumani.
Sukumarini, Sukumani, and Poki and
Yes.
Madhihan. And Sukumani was and it was the case of the plaintiff that Hedma Hemrin died issueless about 25 years ago, and his wife had predeceased him, and consequently the suit property devolved on the legal heirs and successors of the 2 sisters, correct?
Madam, 2 sisters.
2 sisters who were the plaintiffs before the court.
Sons were plaintiffs.
Whose legal heirs and successors
Yes.
were the plaintiffs before the
Madam.
court. It was for the case of the suit was filed only for declaration of right, title, interest and possession with respect to the suit property. However, the defendant filed a written statement and asserted that it was for the case of the plaintiff that the defendants were litigating under moneyed person, and they had set up a lady, namely Mangli Manjian, purported to be widow of Ruplal Hemram, and got a sale deed number 10859 dated 8/1/85 executed in respect of the suit property. And it was the specific case of the and the cause of action arose when defendants were threatening to dispossess the plaintiff. The defendant appeared and contested the suit and alleged that there was no cause of action It was alleged that Hidma Hemram, son of Mandal Hemram, was also known as Rupur Hemram and sometime as Hidma Hemram, and the name of Mangli Manjain, widow of Hidma Hemram, was not shown in the genealogical table filed by the plaintiff. It was the case that Mangli Mahajan Majiain inherited the entire property, fell in the share of her husband, Rupru Hemram. It was false to say that wife of Hidma Hemram predeceased him, and the sisters had inherited the entire properties mentioned in Schedule B of the plate. It was denied that the defendants had set up any woman, namely Mangli Manjain, purported to be wife and widow of Ruplal Hamram for execution of sale deed number 10859 dated 8/11/1985 with respect to Schedule C property. The following issues were framed by the learned trial court. Including the issue number 4, whether Mangli Manjain is wife of Rupu Hemram alias Hidma Hemram. इसको कोट करना है सारे इश्यूज को. The learned trial court while deciding issue number 4 has considered the evidence on record and including the death certificate of Mangli Manjain, which showed that she died on 13/12/1988. Which showed that she was wife of Rupu Manjain and died on 13/12/1988. The learned court also considered the materials to come to a conclusion that after the date of the learned trial court ultimately decided issue number 4 in paragraph 52 that on the basis of oral and documentary evidence, it was clear that Ulpur Hendram is the name, alias name of Hedma Hendram, and Mangli Mahadine was his wife. And also recorded that after his death, she inherited the property, his property was inherited by the widow. The issue number 2 with regard to cause of action was also decided against the plaintiff. The issue number 1 was decided by holding that the suit as framed was not maintainable. The issue number 3 and 4 were dealt with together, and all just the trial court decided all the issues against the plaintiffs. The appellate court also considered the materials on record and gave concurrent finding. The appellate court has also relied upon the permission granted by LRDC, which was exhibited as Exhibit E, which was the certified copy of order of MR case number 129/85 dated 15/11/1985, by which LRDC had granted permission to Mangli Manjain under Section 46 of the Tobacco Tendency Act, and other documents to show that the deed was executed and the possession was handed over to the defendants. The point for determination, was framed in paragraph number 16 as follows. And all the points for determination were decided against the plaintiff/appellants. Thus, there are concurrent findings recorded by both the courts. Thus, the case of the plaintiffs, that wife of Hedma Hendram predeceased him 25 years ago, was completely disbelieved by both the courts by referring to both documentary and oral evidences, and even the death certificate of Manjian. Mangli Manjian was duly exhibited, who died in the year 1988, and the sale deed in the registered sale deed in the incident case was executed in the year 1980. Before this court, the learned counsel has essentially referred to the provisions of Section 46 of the Tobacco Tendency Act to submit that the LRDC had no jurisdiction to grant permission for sale under Section 46. And therefore, the sale itself was null and void. This court finds that no such point was ever raised before the learned courts. And otherwise also, the definition of deputy commissioner, that the term deputy commissioner has been defined under Section 6, under Section 3, within bracket Roman 8 of the Tobacco Tendency Act, which reads as follows. This court is of the considered view that On the basis of the definition of Deputy Commissioner, the aforesaid point the aforesaid point is it cannot be said expressly that the permission having not been granted by Deputy Commissioner and having been granted by LRDC was null and void or void ab initio. It certainly requires an adjudication had such a point been raised before the learned court. It was admittedly not raised. Rather, this court finds that even the sale deed, even the registered sale deed was not under challenge before the court. The learned counsel has also raised a point that why that under tribal society, under tribal custom, why it cannot have absolute right to sell the property of her husband. However, such plea was not taken before both the courts, and further, custom is required to be pleaded and proved before the court of law. And different tribes are governed by different tribal customs. So far as the judgment which has been relied upon by the learned counsel for the appellant reported in the case of Maritus Tirki Supra, this court finds that in the same case the suit was filed seeking a declaration that the permission was illegal, void and without jurisdiction, and consequently the sale deed was void, illegal and inoperable. The legality and validity of the permission and the sale deed was directly in issue before the court. In the present case, the sale deed was never challenged by the plaintiff. Even the permission was never challenged by the plaintiff. On the face of the facts of this case, it cannot be said that the permission or the sale deed, the permission or the sale deed was fully without jurisdiction. Such an issue would certainly require evidence had the sale deed or the permission were subject matter of challenge before the courts. In view of the aforesaid facts and circumstances, the aforesaid two questions which has been suggested by the learned counsel for the appellant does not arise for consideration as substantial question of law in the present proceedings. Accordingly, this appeal is hereby dismissed. Yes, I did that.
After case item 6 for supplementary is second appeal 161 of 2022.
Well, cell deed is not easy. Now, my lord, so far as the only query regarding which of the cell deed has been first executed, my lord, kindly have a look to the my lord, this page number 5, 6, my lord.
You see, there is a concurrent finding that the
Yes, yes.
sale deed is indefinite. It's not well defined.
That concurrent finding is purpose.
How do you say?
Yes. Now, my lord, kindly have a look to my lord, internal page 6 of trial court judgment.
Six of trial court judgment.
Yes, my lord. First exhibit 1 by B is there, my lord. Kindly see the number of the cell deed. This is 2843. Now, my lord, kindly see exhibit 1 by D, my lord. This is my cell deed. This is 2842. Now, my lord, both the courts have held that in my cell deed, details of Benu Chandra Chaudhary is not there. So the perversity committed by both the learned courts, my lord, that since both the courts have failed to consider that my cell deed was of the prior cell deed, and as such there could have no occasion, and this previous cell deed will prevail over the subsequent cell deed. This point has totally been ignored by both the judges.
You read para 11 of the trial court judgment.
My lord. Considering the issues involved in this suit and considering the main dispute between the parties, in my opinion, registered sale deed number 60 dated 21/1992 is the most important document to be taken into consideration to determine the issues involved in this suit. In the said deed, boundary of the land is specifically mentioned, and it is also specifically mentioned that within the boundary of 2000 square feet of land has already been sold by the vendor in favor of Sudha Rani Singh, and he is transferring rest of the land in favor of Krishnakar Pandit. Has there been any map attached with the sale deed, then no confusion would have been caused. But because of the vagueness created due to absence of map, the whole dispute and controversy has been brought up. However, the recital made in the sale deed is very clear and specific, and I have no doubt to come to the conclusion that the land of this defendant Sudha Rani Chaudhary is situated within the boundary as given in the cell deed number 60 dated 21/1992, exhibit 1 by A and exhibit A by 2. There is no dispute that Krishnakant Pandit had purchased 10155 square feet of land from Badri Narayan Parihar and is rightful owner of the same. And similarly, the plaintiff Panjanand Singh, being purchaser from Krishnakant Pandit, has valid title over his purchased area of land. The vendor of the plaintiff Krishnakant Pandit sold the land to the plaintiff and one Benu Chaudhary by registered sale deed with the map attached to the deed. But the vendor himself did not have any map attached in his own sale deed. As the vendor did not have any specific boundary of the land, he had no right to sell his land to other person by specific boundary and with the map of the land attached to the deed. Considering the documentary evidence introduced by the parties as well as oral evidence of the original owner, Badri Narayan Parihar, in my opinion, it cannot be said that defendant Sudha Rani Sinha has imposed upon the lands of the plaintiff. So far, contention of the plaintiff regarding illegality of rectification of the deed of sale deed is concerned. In my opinion, there is no illegality in executing such rectification deed by vendor of defendant Sudha Rani Sinha. Section 26 of the specific relief act may be invoked by either party to a deed where one party demands and the other party denies. But when both the parties to the deed are agreed to the registered sale deed rectified, then it may be subject to any other law or rule. It cannot be said the same is barred under section 26 of the Specific Relief Act.
What about the appellate court?
Appellate court's finding starts from internal page 7, paragraph 8.2.
Just a minute. You read from para 7, point of view. It is just a case of encroachment of two neighbors.
Two neighbors. Whether the dismissal of suit by the trial court is justified in law and facts, whether there is any encroachment on any property belonging to the plaintiff by the defendants, whether the findings of the trial court with respect to section 26 of a Specific Relief Act is correct. Unnecessarily, the irrelevant arguments were conducted in the court by the appellant side, and irrelevant issues were flared and raked up, which has no significance with the suit. Basically, the appellants are not having their own names, wanted to stand on the feet of the respondents. Why this court says so shall be discussed hereafter. Before proceeding further, it is pertinent to determine the source of properties and how they were purchased and what is their derivative title of the property. The following flow chart shall explain the derivative title, and thereafter boundaries of each purchase plots will be explained. It is pertinent to mention that below chart is admitted by both the parties. Thereafter chart is there. Now in the chart, my lord will find that land sold to the Sudharani in the year 1991 and to Krishnakant Pandit in the year 1992. Or again Krishnakant Pandit sold two parts of the land to two persons, and one of them is plaintiff Panchanan Pandit.
Panchanan Pandit and Panchanan Singh are one and the same person.
My lord, the same person. Same, because it is written plaintiff. Para 8.2. From the sale deed of Sudharani, it is explicit on the north. On the north, there is land of Badri Narayan Parihas, and on the south side there is also land of Badri Narayan Parihas, and on the east there is Moja Purgura, and on the west there is 15 feet proposed road. There on both the direction north and south, there is land of Badri Narayan Parihas. Parihas. Further, if we see the boundary of the sale deed of Krishnakant Pandit Chaudhary, it shows that on the this is relevant. It shows that on the north there is land of Bardina, and on the south there is a circular road. Rest of directions are not disputed. The Krishnakant Pandit is the vendor of Binu Chaudhary and Panchanan Singh. If we see the boundaries of the sale deed of Binu Chaudhary, it shows that on the north there is land of Krishnakant Pandit, and on the south the land of Krishnakant Pandit, which is to be sold to Panchanan Singh. The rest of directions are not disputed. Further, if we see the boundaries of the sale deed of Panchanan Singh, on the north there is land of the Krishnakant Pandit, on south circular road, and rest of boundaries are not disputed. In the sale deed of Panchanan Singh, nothing is mentioned on which side the land is being sold to Binu Chaudhary. And whereas on the land of Binu Chaudhary, it is written that on the south side of her land, the land is proposed to be sold to Panchanan Singh. That means that Panchanan Singh was on the south side of Binu Chaudhary. When Panchanan Singh is on the south side of Binu Chaudhary, then automatically Binu Chaudhary is on the north side of Chandan Chaudhary. Further, in the sale deed of Binu Chaudhary, it is mentioned that on both north and south side, there is land of our vendor Krishnakant Pandit. Therefore, firstly from the north, there will be land of our vendor Krishnakant Pandit, and then the land of Binu Chaudhary, and then the land of Panchanan Singh. तीन लैंड में इसको डिवाइड कर दिए. It is also very much clear that there is no gap between the land of Binu Chaudhary and Panchanan Singh, and their boundaries are adjoint. Further, from the boundaries of the cell deed of Krishnakant Pandit, it is very much clear that on the north side there is land of his vendor. The contention of the appellant plaintiff in para 10 of the original claim is falsified by the fact that on the north side of the plaintiff Panchanan Singh land there is land of Binu Chaudhary, and nothing is mentioned in the sale deed of Panchanan Singh regarding the existence of defendant Sudha Rani on his north side. Even if the encroachment is done on the north side of the land of Panchanan Singh, then it can be done by Binu Chaudhary and not by the defendant number Sudha Rani, as because to come to the plot of plaintiff Panchanan Singh from north side, someone has to first encroach upon the land of Binu Chaudhary, then come to the plot of Panchanan Singh. It is interesting to know that Binu Chaudhary is not made party to the suit. Neither she or successor in interest has filed any objection. Further, in same para, the plaintiff all gets that suit land is encroached by defendant number 1 Sudha Rani, and in para 10 he states that
Who
defendant
is Sudha Rani? From whom she has purchased?
Sudha Rani, that's a minor, very outside I said minor. The
Sold to
flowchart is
Sudha
not
Rani.
original owner.
2000.
Yes, 2000 square feet. Now rest of the lands has been sold to Krishnakant Pandit. Krishnakant Pandit sold entire lands to these two persons, Binu Chaudhary and plaintiff. Now the issues was, the trial court, my lord has found, the trial court said that there is no boundary, and my lord has found that in the appellate court also, on page number 8, appellate court has himself taken note of this, that in the cell deed of Panchanan Chaudhary, boundary in the north such, south such. So boundary was there. So this finding of trial court was perverse. Now appellate court has what?
इसको खत्म
By
करते हैं.
it can be done by Binu Chaudhary and not by the defendant number 1 Sudha Rani, as because to come to the plaintiff Panchanan Singh from north side, someone has to first encroach upon the land of Binu Chaudhary and then come to the plot of Panchanan Singh. It is interesting to know that Binu Chaudhary is not made party to this suit. Neither she or successor in interest has filed any objection. Further, in same para 8, the plaintiff all alleges that suit land is encroached by the defendant number 1 Sudha Rani, and in para 10, he states the defendants encroached upon the suit land. The description of the defendant in para 10 is vague description as to which defendant has encroached upon the suit property of the plaintiff. It is impossible for Sudha Rani, defendant number 1, to encroach upon the land of the plaintiff without bypassing the land belonging to the Binu Chaudhary. Nothing is there in the plan to show the actual dimension of the side of the plaintiff plot and how much are on the north side wise dimension wise encroached. The pleadings are vague. In that respect, the very case of the plaintiff is falsified by the cell deed of the aforesaid party. It would therefore be futile to exercise to further delve into oral evidence when the documentary evidence are sufficed to adjudicate the matter. Further, the contention of
Okay,
the
heard the learned counsel appearing on behalf of the applicant. The learned counsel for the applicant has submitted that both the courts have dismissed the suit filed by the plaintiff primarily on the ground that in the sale deed of the plaintiff, Binu Chaudhary was not shown as sharing boundary with the plaintiff. Yeah, na?
well,
He has submitted that the sale deed in favor of Binu Chaudhary as well as the plaintiff was executed on the same day. And considering the number of the sale deed of the plaintiff was prior in point of time. he submits that under such circumstances there was no question of mentioning the name of Binu Chaudhary in the boundary of the plaintiff. The learned counsel has also submitted that the boundary of a sale deed cannot be decided on the basis of boundary mentioned in another sale. Yeah.
My lord. And the appellate court has committed, my lord, perversity. The appellate court has, my case was for declaration of my title over my land purchased by the
The learned appellate court has, he has also submitted that the learned appellate court has committed perversity by observing that it was impossible for Sudha Rani, defendant number 1, to encroach upon the land of plaintiff without bypassing the land belonging to Binu Chaudhary. यही ना?
my lord.
बताइए कौन सा क्वेश्चन ऑफ लॉ?
The question of law.
See,
My lord.
considering that he has submitted that the appeal be admitted on substantial question number C as framed in the memo of appeal, which is quoted as under. Considering the submissions, this appeal will be heard on the aforesaid substantial question of law. Issue notice to the respondents for which requisite under ordinary process be filed by the applicant within a period of 1 week. Let the records be called for the concerned court.
Degree.
Date 20 मार्च को रख.
My
From daily list, item 14, second appeal 115 of 2020.
अप्लाई है आपका बनाकर. सूट क्या चीज के लिए फाइल किए थे?
वो फाइल है दोस्तों इलेक्ट्रिक क्लेम परमानेंट रहती राइट
Where is the relief? सूट का रिलीफ लिखा है. That is सूट. Claim for. पढ़िए जरा. Seeking a declaration that the sale deed number 6093 dated 25/11/2003 is void, illegal and without jurisdiction.
लॉट से
And for recovery of.
इफ डिस्पोजेस
Sorry? And decree for if and when the plaintiff is found dispossessed. So, वो दिखाइए. Issues.
इट हैज कम ऑलरेडी इन द एग्जीक्यूटिव लॉट से
Issues दिखाइए.
ये मे गो द ट्रायल कोर्ट लॉट जजमेंट
Para 10.
पेज नंबर 108 इंटरनल पेज 25 एग्जीक्यूटिव लॉट
Exhibit
Yes.
page number 11 of the trial court judgment. Para number 10.
इनिशियल
Initially देखते हैं ना भैया.
अच्छा, ठीक.
शुरू से देखना पड़ता है. शॉर्टकट में नहीं चल सकते. ट्रायल कोर्ट का क्या फाइंडिंग है, एपीलेट कोर्ट का क्या फाइंडिंग है, उसके बाद ही क्वेश्चन ऑफ लॉ टेस्ट.
पारा 10 पारा 1 पेज 10 पारा 1
Issue इशू नंबर 8 का फाइंडिंग दिखाइए। इशू नंबर 8
Issue number 8. Issue number 8. Whether transfer made by settlement number 6093 dated 25/11/2003 is lawful and valid
आप कौन सा पेज नंबर पढ़ रहे हैं?
ये 12 इंटरनल पेज 12
ट्रायल कोर्ट का
ट्रायल कोर्ट से बिफोर रिमांड
बिफोर रिमांड।
बिफोर रिमांड जो है मेरे पेपर में आफ्टर रिमांड किया तो नोट किया
तो ये जब रिमांड करके ऑर्डर जजमेंट सेटिस्फाइड हो गया तो उसको क्यों ही पढ़ रहे हैं? तो रिमांड के बाद जो जजमेंट आया उसको पढ़ेंगे ना।
अब ये तो ट्रायल कोर्ट की है
लिमिटेड रिमांड था कि ओपन रिमांड?
नहीं रिमांड था ये स्पेशल आफ्टर रिमांड
ओपन रिमांड था कि लिमिटेड रिमांड?
नहीं लिमिटेड रिमांड
कहाँ है रिमांड का ऑर्डर?
ये रिमांड का ऑर्डर है
लगाए हैं इसका?
रिमांड ये 105
पेज नंबर बताइए।
105
हाविंग वर्ड लिखिए पैरा 21 पढ़िए तो। पैरा 21 पढ़िए पेज 8। पूरा रीट्राई का है, लिमिटेड रिमांड नहीं।
having heard the learned concept
पूरा पूरा ओपन रिमांड, लिमिटेड रिमांड नहीं है, ओपन रिमांड है। आप समझ रहे हैं ओपन रिमांड और लिमिटेड रिमांड का?
अब प्रेस रिटर्न है
रीट्राई ना? हाँ तो लिमिटेड रिमांड नहीं है, ओपन रिमांड है। हर इशू को फिर से डिसाइड करना है। तो इस ऑर्डर का कोई मायने नहीं करेगा, इसलिए इसको मत रखो। अब फ्रेश जो हुआ है उसको रखो।
ना कि बिफोर रिमांड में ये लॉस हुआ मेरे फेवर में ये आता है
उससे कोई मतलब नहीं है ना। जब रिमांड हो गया तो सारा इश्यूज ओपन हो गया ना।
फाइंडिंग तो कम से कम आ गया ना
फाइंडिंग तो सेट असाइड हो गया ना, तभी ना रिमांड हुआ। बिना जजमेंट का सेट असाइड हुआ कोई रिमांड होता है? बताइए।
इसमें शेड्यूल
And thereafter would allow to lead evidence and then a fresh judgment would be passed by the court on the new material available without being prejudiced by the सब कुछ तो लिखा हुआ है। पुराना कहानी नहीं सुनी, नहीं समझ में आ रहा है तो भाई आप जानिए, उसके लिए हम कुछ नहीं कर सकते।
the issue is whether the Sudha Napi died issueless or
फाइंडिंग दिखाइए,
हाँ
ट्रायल कोर्ट का फाइंडिंग दिखाइए।
फाइंडिंग कहीं नहीं है
फाइंडिंग रिकॉर्ड ही नहीं किए हैं।
नहीं मूव कोर्ट में है कि दे हैव नॉट प्रूव्ड neither plaintiff nor defendant
सुधा नापित executed stated
ये सुधा ये चार्ट में दिख गया जिनोलॉजिकल टेबल पर
सुधा नापित कौन सा सेल्ड एग्जीक्यूट?
ये सेकंड पेज में जिनोलॉजिकल टेबल मगर नापित has two sons Mahkum Napi and Sudha Napi
एग्जिबिट नंबर
exhibit one है one और A both are exhibits in this case lordship Mahkum Napi has one daughter Abala Napi Naptian according to plaintiff lordship but defendant has stated that Sudha Napi has not died issueless, but he has got one daughter, Lydia Napian. And after that, defendant number 3 lordship, he is the grandson, maternal grandson of lordship.
एक चीज आप एकदम क्लियरली सुन लीजिए, आप अपना जो ट्रायल कोर्ट का जजमेंट है आफ्टर रिमांड उसको पढ़िए, बिफोर रिमांड का कहानी मत सुनाइए, बहुत सा जजमेंट सर्टिफिकेट उसका कोई रेलेवेंस नहीं है, हम नहीं देखेंगे उसको, देखेंगे तो मेरा जजमेंट पर्पस हो।
नहीं, कम से कम एग्जिबिट तो देख लिया जाए।
एग्जिबिट क्या देखना है, एग्जिबिट ट्रायल कोर्ट में नहीं कंसीडर किया है क्या?
नहीं,
ट्रायल कोर्ट में कौन सा एग्जिबिट नहीं कंसीडर?
ये एग्जिबिट
एग्जिबिट नंबर बताइए कौन सा?
एग्जिबिट 1 लॉर्डशिप।
एग्जिबिट 1 हैज नॉट बीन कंसीडर्ड बाय द ट्रायल कोर्ट।
देख लिया जाए इसमें।
चलिए ट्रायल कोर्ट का जजमेंट दिखाइए।
हाँ, ये
पेज
पेज
नंबर
नंबर है, पेज नंबर है, इंटरनल पेज है 25 लॉर्डशिप। हम पोजीशन में है अकॉर्डिंग टू सेल रीड नंबर 3398 एक्सिक्यूटेड ऑन 87 लॉट्स। इसमें टोटल एरिया है 3.21 एकड़ लॉट।
एग्जिबिट नंबर बताइए।
एग्जिबिट नंबर 1 पेज
एग्जिबिट
नंबर 25 इंटरनल पेज 25 और 66। इसमें साफ लिखा हुआ है ओरिजिनल कॉपी ऑफ रजिस्टर्ड सेल डेट डीड नंबर 8379 डेटेड 16/10/87 ई द वेंडर श्रीमती अवाला नपिया ट्रांसफर दी शेयर्स ऑफ हर फादर लेट महबूब नापी एंड शेयर ऑफ हर अंकल लेट सुधा नापी that issueless. It has already been decided in the 87 laws.
ये डिसीजन है क्या? ये डिसीजन नहीं है ना, ये तो रजिस्टर्ड सेल डीड में लिखा है।
हाँ, रजिस्टर्ड सेल डीड में है।
तो वो अगर मान लीजिए कोई चीज रजिस्टर्ड सेल डीड में कोई डिनोलॉजी होता है
One is not lawful and confirmed by the father of the defendant number 1 laws. ये सेल डीड में आया हुआ है। Attesting witness of the ये है। डिफेंडेंट नंबर 1 के फादर जो है वो अटेस्टिंग विटनेस है। ये भी आ चुका है जजमेंट। अच्छा, ये टोटल एरिया 3.21 एकड़ लॉट। ये चैलेंज किए हैं ओनली 24 डिसमिल लॉट्स विदाउट कैंसिलेशन ऑफ द डीड सेल डीड। कैंसिल होगा तो पूरा एरिया होगा। He has himself, defendant number has also filed exhibit A lawsuit in the bottom lawsuit filed by the defendant lawsuit, and this is also executed by the Avala Napian lawsuit.
इश्यूज है ना इसमें, कौन सा इशू इम्पोर्टेंट है, कौन सा इशू इम्पोर्टेंट है? आपकी बात मेरे समझ नहीं आ रही।
Whether the deed is right or wrong, valid or invalid.
आप सेकेंड अपील बहस कर रहे हैं ना, क्या रिलीफ था, क्या रिस्पेक्टिव केसेस था, ये सब कुछ नहीं बहस करेंगे। वेदर द डीड वाज राइट और रॉन्ग,
Without considering the
आप हमको बताइए। योर रिलीफ वाज इन कनेक्शन विद सेल डीड नंबर 6093 डेटेड 25/11/2003।
lawsuit.
हाँ, का उसका फाइंडिंग कहाँ है? राइट कोर्ट में कहाँ है उसका फाइंडिंग, दिखाइए।
Pardon, 60.
यस, वेयर इज द फाइंडिंग?
Just a minute. Page 62.
पेज 62
Lawsuit.
किसका पेज 62? यहाँ
ये
4
trial
पेज
court.
नंबरिंग है आपके ब्रीफ में ना, देयर आर 4 पेज नंबरिंग। 45 लिखा है, 68 लिखा है, 74 लिखा है, 128 लिखा है और इंटरनल पेज 45 लिखा है। कौन सा पेज नंबर मांगे हैं?
इंटरनल
इंटरनल पेज, इंटरनल पेज
62
62. टू में क्या पढ़ना चाहते हैं? 61 में क्या पढ़ना चाहते हैं?
61 पेज 61 पैराग्राफ फर्स्ट
पैरा नंबर तो है ही नहीं कोई पेज 61 में.
ये the court reached on the conclusion with respect of the move question.
कौन सा आप ट्रायल कोर्ट पढ़ रहे हैं, क्या पढ़े?
ट्रायल कोर्ट पढ़ दोनों को टाइप है नहीं आपका दिमाग
कहाँ आप पेज नंबर दिखाई जरा इनको पेज नंबर 61.
61 लॉट से
हाँ तो 61 नहीं दिखाई. ये पेज नंबर 61 ही तो है नीचे. हम ये पेज खोल के बैठे हैं. बताइए आपका पेज. आप इसमें से देखिए ना, आप मेरा रिकॉर्ड से टैली नहीं करेगा आपका तो कैसे चलेगा? या तो रनिंग पेज नंबर बताइए या इंटरनल पेज बताइए. तो इसमें कौन सा पेज पैरा नंबर है? इसमें कोई पैरा नंबर है?
पैरा नंबर फ्रॉम द टॉप लॉट.
कौन सा पैरा नंबर है?
ये कंसिडरिंग फ्रॉम द टॉप ऑफ द बॉडी.
कोई पैरा नंबर तो नहीं है ना, तो फिर पैरा नंबर बोल रहे हैं तो क्या क्या ही हमको समझ में आएगा? इसमें कोई पैरा नंबर ही नहीं है. पढ़िए.
Considering all the facts in its totality, the court reached on the conclusion with respect to moot question that the plaintiff had held to discharge their initial burden of proof. Dear vendors, Uncle Sudhanapit died issueless, and once it is not proved that the said Sudhanapit had died issueless, it creates reasonable doubt about the entitlement of the remote heir like Abla Naptian to transfer all the shares including suit land plot of the Sudhanapit, also because of the facts reflected from the reading of the executed deeds from the side of defendants, that is from the exhibit B, C, E, read with exhibit F and F1, where transactions have been shown to be done by the alleged vendors, namely Sri Ram Napik, claiming himself to derived his title to first class heir of the said Sudhanapik and
राम नापित कौन है?
Lord,
राम नापित के पिता का क्या नाम?
Ram Napik ये गोवर्धन नापिक Lord. गोवर्धन नापिक है, मगर नापिक है, और ये चार्ट किया गया है गोवर्धन नापिक के तीन बेटे हुए राम नापिक.
इसमें ये जो आप पहला चार्ट दिए इसमें सुधा नापित का नाम नहीं है.
नहीं,
तो सुधा नापित का नाम हम कहाँ पे हमको मिलेगा?
कैडेस्ट्रल सर्वे रिपोर्ट है तीन.
ये इसमें कहाँ है सुधा नापित? मंगल नापित का बच्चा.
मंगल, हाँ, मगर नापिक है.
मगन नापित.
फर्स्ट शेयर हो गया गोवर्धन नापिक, सेकेंड हो गया मगर नापिक, और थर्ड है दुर्गा नापिक.
Plaintiff claimed that Sudha Napit died issueless.
Lost.
But according to defendant number 1 and 2, Lydia Napitan
हाँ, they have stated that
was his wife,
lost.
the wife of Shambhu Napit. Who is Shambhu Napit?
हाँ,
Who is Shambhu Napit?
शंभू नापिक का ये
इनके अच्छा इनकी बेटी होगी. सुधा
according to
नापित की बेटी होगी.
हाँ डिफेंडेंट का according to defendant 1 and 2.
Yes, yes.
हाँ इसमें ये जो कहा गया लॉर्डशिप है डिफेंडेंट नंबर 3 who has stated himself as a legal heir has not filed WS lordship and court has allowed to give deposition of his witness lordship.
There is a finding that all the defendant witnesses have said that Sudha Napit had one daughter.
किसी का क्लियर नहीं है कि कब डेथ हुआ क्या हुआ neither defendant nor plaintiff. और दोनों कोर्ट का ये
आपका एग्जिबिट्स में भी तो है. Exhibit B, C, E, F and F51 where transactions have been shown to be done by the alleged
all
vendor.
exhibit has done after 2003 lordship और हमारा 87 से है लॉर्डशिप और हमारा 3.2 का देखा है लॉर्डशिप. टोटल एग्जीक्यूट देखा जाए तो किसका है 24 डिसमिस आउट ऑफ 27 डिसमिस वो भी कंप्लीट नहीं है.
Non-joinder of necessary parties.
हाँ
वो है ना. तो non-joinder of necessary parties के कारण अगर सूट डिसमिस हो जाएगा
ये
तो उसका क्या करेंगे बताइए. कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ हम फ्रेम भी कर देंगे तो आपको क्या रिलीफ हम दे सकते हैं. There is clear non-joinder of necessary parties. Non-joinder of necessary parties are concerned since the defendants have raised specifically the fact in issue in their written statement in that the suit is liable to for non-joinder such as खदरू नापित. इनको ये सब नाम लिख कर लिखे हैं कि आपने उनको पार्टी नहीं बनाया. जो एग्जिबिट 1 में जो जॉइंट से लीड है उन्होंने उन लोगों को भी अपनी पार्टी नहीं बनाई जिसके बेसिस पे आप क्लेम कर. तो नॉन जॉइंटर ऑफ नेसेसरी पार्टी में फिर आपको क्या ही रिलीफ दे सकते हैं. सूट इज सफिशिएंट फॉर नॉन जॉइंटर ऑफ नेसेसरी. आप पोजीशन भी अपना एस्टैब्लिश नहीं करते.
पोजीशन पूरा ये भी नहीं दिखा पाए हैं.
आप तो नहीं प्लेंटिव को दिखाना है ना. वो क्या दिखा पाए इससे क्या ही लेना.
प्लेंटिव तो पूरा बनाया नहीं पाती. ये तो पहली हाँ 27 में है जिनको बेचा गया जो अभी पोजीशन में है उनको पार्टी नहीं बनाया.
बेचा नहीं आपने सारे लोगों को जो फैमिली में सब लोग हैं उनको भी नहीं पार्टी बनाया.
हमको नहीं बनाया और जो अभी पोजीशन में है स्वागत में था उनको भी नहीं पार्टी बनाया. Suit filed by us, he is a stranger and has imputed civility.
Ram Napit also died. Huh? कब?
ये तो नहीं है.
Defendant number 3.
ना तो श्री राम नापित.
हाँ?
डिपेंडेंट मतलब श्री राम नापित.
तो राम नापित और श्री
ये
राम
राम
नापित अलग अलग. राम नापित का नाम कहाँ लिखा है?
राम नापित के फादर गोवर्धन नापित.
राम नापित.
ये श्री राम अभी डिपेंडेंट ये तो दिया का आदमी है।
Or the Learning Council appealing on behalf of the applicant.
ये वर्सेस में ये rent is received.
Judges,
Rent is received in the name of the
name of whom?
इनके नाम से सर्विस हुआ है परेश नाथी
The Learning Council for the applicant has submitted that though there are concurrent findings recorded by both the courts, but still there are substantial question of law involved in this case. He submits that the learned trial court was wrong in the approach in holding that the plaintiff failed to prove that Sudha Nape died issueless. the learned counsel has submitted that the entire case revolves around as to whether the recorded prayer Sudha Napit died issueless or he left behind one year slash daughter, namely Lydia Naptiani. The learned counsel submits that the plaintiff was claiming title by virtue of CLD number 4697 dated 15/6/1987 executed by Abla Naptani in favor of Antulal Mahta. And his safety was exhibit.
Exhibit 1.
CLD date का कुछ CLD number 8379 dated 16/10/87 यही लिखा है कि दूसरा लिखा है CLD number 8379 dated 16/10/87 within bracket exhibit 1 executed by Srimati Abla Naptani who transferred the share of her father late Mahakum Napit and the share of her uncle, late Sudha Napit, by claiming that Sudha Napit died sonless. He has submitted that the findings recorded by the learned courts are perverse. The suit was filed. This court finds that the plaintiffs had filed a suit seeking declaration of their permanent royalty right over the suit land and seeking a declaration that the CLD number 6093 dated 25/11/2003 was void, illegal and without jurisdiction and sought cancellation of the same and also sought recovery of possession if and when the plaintiffs found dispossessed. They also sought a relief of permanent injunction. The case of the plaintiff was that the land was originally recorded in the name of Ram Napit, Syam Napit and Chatru Napit, all sons of Govardhan Napit in one part, and Mahakum Napit, Sudha Napit, both sons of Mangan Napit in the second part, and Dina Napit, son of Durga Napit, Tulya Napit, widow of Chatru Napit in third part, in last cadastral survey operation. It was their case that Ram Napit died issueless. Shyam Napit died leaving behind his son Ganesh Napit, Kubla Napit and Vishu Napit, and Chatru Napit died issueless. Accordingly, the share of Ram Napit and Chatru Napit devolved upon their sons, namely Shyam Napit. Makkum Napit died leaving behind his only daughter, Abla Napit, and Sudha Napit died issueless. And it was a specific case of the plaintiffs that on account of death of Sudha Napit, who died issueless, the share of Sudha Napit devolved upon Abla Napit. The daughter of Mahakum Napik, namely Srimati Abla Naptain, who was enjoying her own share and also the share of Sudha Napik, transferred the entire share by virtue of the sale deed dated sale deed number 8379 dated 16/10/1987. In the name of Vishu Napik, Mangal Napik, Paresh Napik, Mangal Napik, and got their name mutated. And also remained in possession of land, including plot number 3398 by adverse act of possession. While in possession, there was amicable partition amongst Paresh Napik, Vishu Napik, and Mangal Napik. It was their further case that in the month of April 2005, the defendants managed a panchayati to get the dispute decided, and the sale deed number 6093 found in possession of the defendant was found to be illegal and without jurisdiction. The defendants in the month of September 2006 forcibly entered into the suit land and tried to take foundation, and consequently the cause of action arose and the suit was filed. Seeking a declaration that sale deed number 6093 dated 25/11/2003 executed by Shri Ram Napit in favor of Shakti Pramani and Kailash Mahta was null and void. the defendants filed their written statement raising serious objection with connection with non-joinder of necessary parties and it was their specific case that Su land was belonging to Sudha Napit until his death. He died leaving till his death, and he died leaving behind his only daughter named Lydia Napitan, known as Lydia Napitan, who married Shambhu Napit. She had a son named Bukka Napit, and Bukka Napit died leaving behind only son Ram Napit. Nidhiya Napitan and Bukka Napit and Sri Ram Napit were in peaceful possession of the property. And while in possession, Sri Ram Napit executed registered deed number 6093 dated 25/11/2003 in favor of Shakti Pramanik and Kailash Mahata for valuable consideration. On the basis of the pleadings of the parties, the following issues were framed. The trial court decided issue number 1, 5, 7, 8 and 9 together and observed that essentially there are three parts of the issue. The main part, the first part is related to question of maintainability of the suit and non-joinder of necessary parties. The second part related to the question of declaration of permanent priority right of the plaintiff over the Schedule B land and for testing the validity of said deed number 6093 dated 25/11/2003, and the third part related to the entitlement of the relief as claimed by the plaintiff. The learned court, after considering the materials on record, found that the moot question involved was as to whether the recorded prayer Sudha Napit died issueless or he died leaving behind his only daughter / here namely Lydia Matani. The learned court considered the materials on record and recorded the finding in paragraph 19 The learned court also considered that the vendor's uncle Sudha Napik, as per Exhibit 1 also, on the basis of which the plaintiff was claiming the title, had stated that Sudha Napik died sonless and sonless, and nowhere it was written that her uncle died issueless. The learned counsel also considered, the learned court also considered the documentary evidences on record and ultimately came to a finding that the plaintiff failed to discharge the initial burden that the vendor's uncle Sudha Napik died issueless. The learned court also referred to the documentary evidences and found that that the witnesses of the defendants had supported the fact that Sudha Napik had one daughter. The learned court also considered that the suit was not maintainable on account of non-joinder of necessary parties and to which specific objection was taken in the written statement, giving the names of the persons who were necessary parties in the proceedings. The learned court was of the view that their rights who were not made parties was directly involved in the suit. The learned court also recorded that the plaintiff did not even prefer to make the other two bendies of the descendants of Exhibit 1, which was a joint seal deed, as party in the proceedings. And the learned court held that the suit was bad on account of not maintainable on account of non-joinder of necessary parties, and ultimately dismissed the suit. The learned appellate court also considered the materials on record and recorded the main issue to be determined as to whether the recorded heir Sudha Napik died issueless or left behind his daughter, namely Lydia Naptine, para 14 of the appellate court. The appellate court also scrutinized the materials on record and also considered the evidence of the PW2, who had also stated that as he considered the materials on record and held that the plaintiff could not prove his case and that Sudha Napik had one daughter. The findings has been recorded internal page 26 of the appellate court judgment. Just report कर लो. Okay, I have just written few. You need to go page में इसको put. This court finds that both the courts have given concurrent findings that Sudha Napik did not die childless but had one daughter. This court finds no perversity in the findings recorded by the learned court, and consequently, no question of law arises, no substantial question of law arises in this significant which is hereby discussed.
कोर्ट में सर अगले 20 तारीख को सब फिक्स किया गया है.